Any additional arguments you'd like to make to the court?
I mean, I can cite the right to travel, which is Second American Jurisprudence, Constitutional Law, Section 329, page 1135, which states personal liberty largely consists of the right of locomotion to go where and when one pleases, only so far restrained as the rights of others may make it necessary for the welfare of all other citizens.
So here's one for you. A guy who thinks driving without a license is protected by the Constitution throws 4 legal citations at a judge to prove it and walks away with 0 of them actually holding up. Case number 25T5884 is called, and Robert Richards is representing himself against a driving under restraint charge and an expired plate. Both traffic infractions, both headed for a bench trial. He's already filed a motion to dismiss, so the judge turns to the prosecutor first. She argues Richards is simply unwilling to resolve the case, but the judge isn't taking her word for it. She asks if the prosecutor actually pulled the cases Richards cited. Turns out, one of them, credited to Shuttlesworth versus City of Birmingham, can't be found by either of them. I'm with the judge here. She's not rubber stamping either side's homework. But Richards wasn't finished. He was about to unload his entire sovereign playbook.
So with that, Mr. Richards, would you like to respond to her arguments to the court as to why I should not grant your motion to dismiss based on the cases you have cited?
Well, we can start with Article 6, Clause 2.
Of which Constitution?
The United States Constitution.
Go ahead.
All persons born and naturalized in the United States are subject to jurisdiction therefore are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of liberty or property without due process of law, nor deny any person within its jurisdiction equal protections under the law. Now I'd like to cite the definition of liberty: the freedom and exemption from extraneous control, the power of the will and its moral freedom to follow the dictates of its unrestricted choice and to direct the external acts of the individual without restraint, coercion, or control from others. I apologize. The first amendment I read was Amendment 14, Section 1. Article 6, Clause 2. All debts, contracts, and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. The Constitution, the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or the laws of any state contrary to the contrary withstanding. The senators and representatives before mentioned and the members of the several states legislatures and all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. The United States Code is the supreme law of the land. All states are required and bound by it. And the USC recognizes no law for a driver's license, for inspection, for insurance, or for registration. And the only law that they do have on the books is regarding registration for commercial vehicles. The word driver is a commercial term, which means that you're using the road for a commercial purpose or for a higher purpose. I have stated since I met with the officer who initially pulled me over that I am a private traveler.
All right. Any additional arguments you'd like to make to the court?
I mean, I can cite the right to travel, which is Second American Jurisprudence, Constitutional Law, Section 329, page 1135, which states personal liberty largely consists of the right of locomotion to go where and when one pleases, only so far restrained as the rights of others may make it necessary for the welfare of all other citizens. The right of the citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not merely a privilege which may be permitted or prohibited at will, but a common right which he has under the right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected not only in person but in safe conduct. And personal liberty consists of the power of local motion to change situations or removing one's person to whatever place one's inclination may direct without imprisonment or restraint unless by due process of law.
Any additional record before the court rules?
I can read the USC that regards the requirement for registration since we have a registration here, but I don't feel like that's really necessary at this point, do you?
Well, that'll be up to you. I'm giving you your time before the court.
Richards closes out his own defense by reading 49 U.S.C. 31704, a federal statute about commercial vehicle registration, insisting it proves he's exempt, since he's a private traveler, not a commercial driver. He tells the judge that's essentially his whole case. This is the classic sovereign move. Grab a real law about commercial carriers and stretch it to cover a personal car when it says nothing of the sort. Now it's the judge's turn to go through every citation, one by one.
And thank you for that. And with that, the court will now rule as follows in this case. As to Mr. Richards' motion to dismiss, he has cited as his legal authority Murdoch versus Pennsylvania, which can be found at 319 U.S. 105. That's a United States Supreme Court case from 1943. And then we have Flournoy versus National Bank of Shreveport, which can be found at 3 Southern 2nd 244. That is a Supreme Court of Louisiana case from 1941. Both are still good case law. The court did try to find this Shuttlesworth versus City of Birmingham. The site is 373. I also looked at 375 US 260. That case does not exist under that site.
Okay.
And as to each of these cases, we are here on this driving under restraint and an expired license plate charges. The first is a Class A traffic infraction. The second is a Class B traffic infraction, ineligible for a jury trial, but a court trial. And as to Flournoy versus the First National Bank of Shreveport, the actual issue in that case is that they did challenge, and that would be Flournoy challenged a statute that was limiting in-value bank shares for taxation. The court found that that was unconstitutional. It has no bearing on a driving under restraint or a license plate being expired. And then in Murdoch versus Commonwealth of Pennsylvania, what was happening there is that the city of Jeanette, and it was an ordinance by the city of Jeanette in Pennsylvania, was prohibiting the sale of goods, wares, and merchandise of any kind within the city by canvassing for or soliciting without a license. And the United States Supreme Court found that that was in violation of the Constitution, the United States Constitution, freedom of speech that is guaranteed by that First Amendment, because it was preventing people that had religious beliefs or were on the streets just preaching the gospel from distributing religious literature and then having personal visitations with individuals as they walk by. And they found that that requirement prohibiting any sale of goods, ware, or merchandise of any kind without a license was in violation of the First Amendment. And so as to all that has been cited by Mr. Richards, I appreciate it, but we do have laws here in the state of Colorado that do require you to have a driver's license and that privilege, and also have your vehicle license. And so as your motion to dismiss the charges in this case, that will be denied.
With the motion denied, the hearing shifts into standard housekeeping, and this stretch is mostly procedure. Richards hasn't picked up his discovery yet, so the judge walks him through it. The state has 5 media files total, a witness list naming 3 or 4 officers, and deadlines for both sides to agree on what evidence comes in. Any expert witness needs a CV and a summary of testimony filed by October 3rd. Richards briefly interrupts to ask if the court is ignoring his right to locomotion. The judge calmly explains no such right covers driving without a license. It's dry material, but it shows her staying patient and thorough, even as he keeps trying to pull the hearing off track. Then things almost took a different turn.
So if I just want to pay the fines now, you're obviously not going to side with me in this. So if I just want to pay the fines and walk away from it.
I'm not either siding with or for against anyone. I just follow the laws here in the state of Colorado.
My right to liberty is invalid, so If I just want to pay the fines and walk away from this, what?
No, you have rights and you have liberties, but also here in the state of Colorado, these are valid charges.
Not in the state of Colorado. I'm a man standing on land. I am not a dead entity inside of a state.
Okay. Would you like to enter into a plea agreement then with the people?
What are we looking at for fines?
Well, I can do, can we pass, Your Honor, while
You
we're
may.
discussing?
So this October 3rd, do I need to worry about that in this particular instance?
You still would,
I would.
if you would like to see
So I
what
need
the
to-
discovery is and if you want to object to anything.
All right.
So there's some additional deadlines. And so we are back on the record on Robert Richards, case number 25T5884. He is present before the court and so is Ms. G for the people. And so if there are any objections to any redactions or lack thereof of those media files, in other words, people are going to use something that you don't think they should be able to use, or they're not going to use something that you believe they should be used. You must state that in writing and you must support it by a legal basis. In other words, you just can't say object. I have to know why you're objecting under the law. And you must tender oath to the court the media in question by that next Friday, which would be October 10th. Now, failure to, even though you may have submitted a written objection that's supported by a legal basis, if I do not also receive the media in question by that next Friday, October 10th, then the court will deem the objection to be abandoned. And the reason why is this, I don't have access to their discovery. And so I don't have the media files. I have to be able to have the media file to review it, to be able to rule on it. Now, within that same written objection, the opposing party, you may respond to that objection with your own legal basis. But if you fail to respond, the court could deem your refusal or failure to respond as a confession of that objection. And I could grant that objection as written. But irrespective of if there is a response or not, if a written objection is filed supported by a legal basis and the objecting party has tendered oath to the court the media in question by that Friday, October 10th, I will issue a written ruling on the weekend of October 18th. And so with that, because there were no testimonial motions, all motions and notices have been addressed. JASP order is still in effect. Parties, if they so choose, you may plead out at any point in time. And so with that, anything further for the people before I order Mr. Richards back here for the trial?
Nothing further, Your Honor.
And Mr. Richards, anything further for you before I order you back? And so I do order you to pay back here, and we will see you back here on October 22nd. That will be a Wednesday, and that'll be at 8:15 a.m. Again, Wednesday, October 22nd at 8:15 a.m.
2. Citations that led nowhere. 1. Right to travel argument built on a dismissed filing, and a defendant still convinced paperwork beats the law. I'm going with the judge on this one. She checked the citations herself and gave him every chance to prepare. Right to travel or just a valid traffic law? Let us know in the comments. That's a wrap on another epic case, and honestly, I have so many more where that came from. Drop a comment and tell me what you thought, and make sure you're subscribed to Court with Mia so you never miss the next one. See you there.